Welcome to St. Lucie Public Schools training on ethics and professionalism in the workplace. I'm Aaron Clemens, the Director of Employee Relations. This course serves as a first-time training tool and a refresher for all employees, whether new to the district or for seasoned veterans. Ethics is defined by Webster's New Collegiate Dictionary as a major branch of philosophy that involves analysis of right and wrong conduct. It has also been described as a discipline that deals with duties and obligations to others. As educators and employees of St. Lucie Public Schools, we are held to a higher moral standard both professionally and personally because of our role in educating children. This course will provide you with guidance on the district's expectations regarding ethics and professionalism of all employees, and we will go over policies and procedures so that you stay informed as an employee. The mission of St. Lucie Public Schools is to ensure all students graduate from safe and caring schools, equipped with the knowledge, skills, and desire to succeed. Ethics and professionalism of all district employees is fundamentally necessary for students to graduate from safe and caring schools, equipped with the knowledge, skills, and desire to succeed as stated in the mission statement. Even at times when students are having a bad day and may not be showing the most respect for you as an employee of the district employees must remain the adults. While you are working as an employee of St. Lucie Public Schools, you are representing our district and must remain professional at all times. Everything we do is about the success of students and making sure they have the tools necessary to succeed. With our mission to ensure the success of students, the Principles of Professional Conduct for the Education Profession in Florida addresses professional attitudes, concerns, and ethical conduct towards students, the public, and the profession of education. A teacher who is found to have violated any part of the Principles of Professional Conduct is subject to having his or her license sanctioned by the Education Practices Commission. However, St. Lucie Public Schools adopts the Principles of Professional Conduct for all employees, and all employees are held to these standards. As a representative of the school and the district, employees must demonstrate and uphold standards of ethical conduct both inside and outside of the classroom. As a public employee and a role model to students, colleagues, and parents, employees of St. Lucie Public Schools have a duty at all times to abide by the Principles of Professional Conduct. Therefore, the term educator in the Principles of Professional Conduct is referring to all employees in the district. The Principles of Professional Conduct provides the three ethical principles listed below. First, the educator values the worth and dignity of every person, the pursuit of truth, devotion to excellence, acquisition of knowledge, and the nurture of democratic citizenship. Essential to the achievement of these standards are the freedom to learn and to teach and to guarantee equal opportunity for all. Every person includes all stakeholders such as students, parents, colleagues, vendors, and the community. Second, the educator's primary professional concern will always be for the student and for the development of the student's potential. The educator will therefore strive for professional growth and will seek to exercise the best professional judgment and integrity. Third, aware of the importance of maintaining the respect and confidence of one's colleagues, of students, of parents, and other members of the community, the educator strives to achieve and sustain the highest degree of ethical conduct. As public employees of St. Lucie Public Schools, we are held to a higher standard than those in the private sector. Choices we make in our personal lives can impact our careers and professional reputation. The Principles of Professional Conduct has three sections which St. Lucie Public Schools employees are held to: obligation to the student, obligation to the public, and obligation to the profession. Employees must create an environment that promotes and nurtures learning and a place where students are free from harmful conditions. Educators must work to protect students from mental and physical injury. Touching students is not necessarily prohibited. Elementary age students especially tend to give hugs and show affection. Contact with students is permitted. However, employees should not touch students inappropriately, aggressively, or sexually. It is best to limit physical contact with students to high fives, handshakes, and fist bumps, unless an employee is touching a student in order to protect students, themselves, or others. The three things from this section which cause employees to receive progressive discipline most often are touching students aggressively, making inappropriate comments to students, and making embarrassing and disparaging comments towards students. However, out of these three sections, inappropriate communication with students and making embarrassing and disparaging comments towards students is the #1 reason employees receive discipline. Students will say things to employees and may even act out aggressively toward employees. Employees must remain the adult and cannot make disparaging comments to students, cannot embarrass students in front of their classmates, cannot talk about their disability or medications they take for their disability, or talk about their IEP or 504 plans. Remember that you are the adult and you must keep a level head when dealing with students. Working with students is a rewarding career, yet it can, on occasion, be emotionally demanding. Employees sometimes find themselves in difficult situations where they must interact with and de-escalate unruly students. Therefore, it is imperative that employees know how to manage their own emotions in order to maintain control in these situations and the classroom at all times. Avoid taking a student's behavior personally and do not hold grudges. Students sometimes act out in inappropriate ways because they are experiencing difficult issues at home or school. Becoming angry and visibly upset only intensifies a conflict and can cause the student to act out further. An employee's best teaching tool is their modeling. By handling conflict consistently and effectively, they are clarifying their expectations and promoting positive behavior. More often than not, when employees engage in verbal or physical altercations with students, it is a result of an employee not de-escalating the situation. Inappropriate relationships with students can get employees fired or arrested. School board policy states that employees are prohibited from dating or agreeing to date any student enrolled in the regular K-12 program of the district. Violation of this policy shall constitute gross insubordination and misconduct in office and shall be grounds for dismissal. Inappropriate relationships are not always sexual in nature and include, but are not limited to, exploiting a student for personal gain, having a relationship that is harmful to a student's mental or physical well-being, and any other relationship that violates any provision listed in the Principles of Professional Conduct for the education profession in Florida. Recently, offenses against students by authority figures was amended in the Florida statutes. The statute defines authority figure as a person 18 years of age or older who is employed by, volunteering at, or under contract with a school, including school resource officers. Now, age does not matter when school district employees engage in romantic relationships with students. It is now at least a second-degree felony for a school district employee to have a romantic relationship with any student, regardless of age. In addition, employees shall not have conversations of a sexual nature with students outside of information that is part of the approved curriculum or counseling programs. The possible result for employees who date or agree to date any student in St. Lucie Public Schools are subject to dismissal, criminal prosecution, and loss of their educator certificate if they are a certified educator. Employees must keep all information regarding students' educational and medical records confidential as per HIPAA and FERPA. All information related to a student should only be discussed with the appropriate individuals such as parents or guardians, school administrators, school counselors, or a school nurse. Discussions should take place in a private area at the school, away from others who are not a part of the student's academic success. Employees should never discuss student information with the parent of another child. Additionally, even though district employees may have access to confidential student information, for example, address, phone number, parent or sibling names, and/or IEP or 504 information, employees are prohibited from disclosing that confidential information with anyone outside of district-approved personnel. All questions regarding what an employee can disclose and to whom should be discussed with the employee's supervisor or district administration. The next section of the principal's professional conduct is obligation to the public. Number 1 is, shall take reasonable precautions to distinguish between personal views and those of any educational institution or organization with which the individual is affiliated. An example of this would be making a statement via social media or on another platform that can be viewed by the public. When doing so, you should not state where you work so that your statements are not viewed as the opinions of the district. Number 2, shall not intentionally distort or misrepresent facts concerning an educational matter in direct or indirect public expression. You must make sure that when you are discussing district-related business with the public, that you are not misrepresenting or falsifying the information. Number 3, shall not use institutional privileges for personal gain or advantage. Examples would be selling or pawning school equipment that was provided to you by the district, using monies collected for school fundraisers or for personal use. School board policy states that staff members who tutor students within their school units and receive compensation for this work shall have prior approval of their principal. Additionally, staff members may not accept fees for remedial tutoring of students currently enrolled in any of their classes, and school board facilities and materials shall not be used for tutoring. This includes training a student for sports. Number 4, shall accept no gratuity, gift, or favor that might influence professional judgment. An example would be accepting gifts from students or their parents that might cause you to give that student special treatment over other students. Number 5, shall offer no gratuity, gift, or favor to obtain special advantages. An example would be offering special treatment, such as better grades to a student whose parents own a car lot so that an employee may get a special discount on a vehicle. Obligation to the profession. Employees of a school district are held to a higher standard and must demonstrate and uphold standards of ethical conduct both at their job and away from their job. Employees must also treat students, parents, and colleagues with respect. The district has seen 4 common problem areas under this obligation. Honesty. You are required to be honest in all professional dealings. Falsifying, misrepresenting, or failing to be honest related to your job in the district could result in discipline. Everything you do as a district employee is public record. Malicious and false statements. You must refrain from making malicious and false statements. Do not spread false statements or rumors about another colleague or student. Gossip can be harmful to others and in the workplace overall. Respect and be fair to your colleagues and students. Fraud. Do not submit fraudulent information on any document used in the course of an employee's job duties. Falsifying documents can cause your supervisor and the district to lose trust in your ability for you to perform your job duties. Next, we will go over recent legislative changes that have affected school districts, including library books, instructional materials, and the use of technology resources. The following slides will address those new changes. There have been many changes regarding what library books are allowed in school libraries and the approval process for adding library books. Books that are purchased, donated, or otherwise made available to students must be approved by the school media specialist, school principal, and must include input from community stakeholders. School principals are responsible for the books that are available to students. Do not bring books into the school or into your classroom that are not approved by the media specialist and principal. Classroom libraries are considered school libraries and must have the same approval. As an educator, it is very important to make sure that you are using instructional materials and curriculum that is approved by St. Lucie Public Schools. All instructional material must be a part of the district's established curriculum as outlined on the approved instructional materials list on the St. Lucie Public Schools website. Please direct any questions regarding instructional materials to your administration prior to implementation in the classroom. You may receive emails from companies on your school district email offering you free trials of programs for your students. Beware that these programs are prohibited. Do not sign up for these offers. Did you know that when you agree to terms and conditions on websites or apps, you are signing a contract, and as teachers, you are not authorized to sign those contracts? Since these programs are often curriculum programs, they are also not on the approved and posted district curriculum. Websites such as getepic.com and TeacherPayTeacher are prohibited, and all instructional materials must be approved by St. Lucie Public Schools. There are also statutes protecting students and families from the dangers of data sharing, so all technology platforms are approved by the district's ITS department to ensure and comply with all confidentiality requirements. Utilizing these materials without approval by your administration and St. Lucie Public Schools could subject a teacher to disciplinary action. Next, we will be discussing the recent changes related to our requirements for defining the gender of our students. Florida statute defines sex for school districts, and the definition as follows. Sex means the classification of a person as either female or male based on the organization of the body of such person for a specific reproductive role, as indicated by the person's sex chromosomes, naturally occurring sex hormones, and internal and external genitalia present at birth. It also requires that school districts create a policy stating that a person's sex is an immutable biological trait and that it is false to ascribe to a person a pronoun that does not correspond to such person's sex. The only exception is for people with a specific genetic or biochemical disorder. The law states that no student or employee of a public school can be required to use someone's preferred pronouns if they do not correspond to that person's sex. Additionally, no employee or contractor of a public school may provide to a student his or her preferred personal title or pronoun if such preferred personal pronoun does not correspond to his or her sex as defined in the previous slide. Lastly, an employee cannot ask a student what their preferred pronoun or personal title is. An employee who asks a student for their preferred or personal pronoun may be subject to disciplinary action. The next section covers Florida requirements related to bathrooms. This law requires that all bathrooms be either male or female as determined by birth, and unisex bathrooms must be single occupant use only. Additionally, a person may not enter a restroom or changing facility designated for the opposite sex unless it is to assist a child under 12 or 60 or older, or a person with a disability. There are also exceptions for law enforcement, custodians, and emergency responders, as well as an exception if a restroom is out of order and there is no one of the opposite sex present in the restroom. Lastly, all public entities, including schools, must further establish disciplinary procedures for any employee and/or student who willfully enters a facility designated for the opposite sex for any purpose other than the exceptions outlined above. This slide is strictly for our bus drivers and the bus aides who drive and ride our school buses. Employee Relations investigates several things that happen on school buses each year. This slide is dedicated to advise bus drivers and bus aides how to avoid receiving discipline. Do not leave students unattended on a school bus. Consistent with school board policy and the Safe Driver Plan, if students are left on a bus unattended, it will result in dismissal of the employee who is responsible. Bus drivers and bus aides have been terminated for leaving students unattended on a school bus. If you need to leave your bus, you are required to find someone to cover the bus prior to leaving. Please check your bus after each run or anytime you are exiting your bus. Students may still be on the bus even though you thought everyone had exited the bus. Concentrate on driving the bus. Do not eat or drink while driving or do anything else that takes your concentration away from driving the bus. Placing students in danger because of not paying attention to your driving will result in discipline up to and including termination. Bus drivers have been terminated for not paying attention while driving. Using a wireless device while operating your bus will result in suspension without pay or dismissal. Filing a false workers' compensation claim as a result of an accident may result in disciplinary action up to and including termination. Failing to follow procedures for crossing a railroad crossing will result in suspension without pay or dismissal. Students grades pre-K through first grade are not allowed to get off of the bus without an escort that is in the fourth grade or higher. Do not allow a student to get off your bus if they are pre-K through first grade and do not have an escort. If any student is not comfortable, unfamiliar with their surroundings, or has a question about where they are, you are required to contact dispatch and make sure they are at the right bus stop and know where they are going. If a student does not want to exit your bus, you are required to contact dispatch and take them back to the bus compound. Even though this slide is only for bus drivers and bus aides, drivers and bus aides must continue to pay attention to the remainder of the slides in this presentation because they also apply to all transportation employees. As a district, we hope none of our employees are arrested. However, if you're arrested, school board policy requires that all employees self-report arrests within 48 hours to the Human Resources Department or Employee Relations. A phone message can be left with Human Resources Department 24 hours a day, and a phone message is sufficient for self-reporting. Also, an email is sufficient for self-reporting. Such notice shall not be considered an admission of guilt, nor shall such notice be admissible for any purpose in any proceeding, civil or criminal, administrative or judicial, investigatory or adjudicatory. In addition, self-reporting shall also be required for any conviction, finding of guilt, withholding of adjudication, commitment to a pretrial diversion program, or entering of a plea of guilty or nolo contendere for any criminal offense other than a minor traffic violation within 48 hours after the final judgment. Arrests shall include cases in which the employee was taken into custody, as well as charges of criminal misconduct for which the employee was taken into custody. Convictions shall include any conviction, finding of guilt, withholding of adjudication, commitment to a pretrial diversion program, or entering into a plea of nolo contendere for any criminal offense other than a minor traffic offense. A common definition to allow for uniform interpretation and reporting of a minor traffic violation shall be defined according to Florida statute as follows. Infraction means any non-criminal violation that may require community service hours under Florida statute, but is not punishable by incarceration and for which there is no right to a trial by jury or right to a court-appointed attorney. Criminal traffic violations are not minor and must be reported. School board policy states, it is the intent of the school board that work environments be free of the presence of illegal drugs and alcohol. Therefore, employees are prohibited from possessing, using, manufacturing, dispensing, distributing, or being under the influence of illegal drugs or alcohol while on duty. In addition, an employee who is found possessing, using, manufacturing, dispensing, or distributing illegal drugs or alcohol while on duty will be discharged. School district employees are only subject to random drug and alcohol testing if they hold a CDL license or have been previously disciplined for being under the influence of alcohol or drugs while at work. Additionally, any employee who is suspected of being under the influence of alcohol and/or drugs while at work will be sent for reasonable alcohol and drug testing. If an employee refuses to submit to an alcohol or drug test, school board policy states it shall result in the employee's discharge from employment. So if you've been out drinking for several hours and only get a few hours of sleep when you report to work, you will report intoxicated and you will appear to be intoxicated. It takes several hours of sleep to sober up from a long night of drinking. It is not worth it. Please call in sick. Obviously, never use illegal drugs while you are employed by St. Lucie Public Schools. School district administration does not need to determine whether it is alcohol or drugs that you are under the influence of. All they have to do is suspect that you are under the influence of something, and you will be tested for both drugs and alcohol. Doing illegal drugs outside of work can affect your employment with St. Lucie Public Schools. Even though marijuana has been legalized for medical use in Florida, employers can still hold employees accountable for being under the influence of marijuana. A prescription for marijuana is only a suggestion by a medical professional and does not override that St. Lucie Public Schools is a drug-free workplace. St. Lucie Public Schools still considers marijuana an illegal drug for the purpose of the drug-free workplace policy. In case you are wondering, this also means that you cannot have a flask in your desk drawer, a flask on your school bus, or wine bottles in your desk drawer to relieve stress during the workday. When communicating with students, parents, or guardians, and colleagues electronically, use caution and good judgment. Any information relayed to students, parents, and colleagues shall be professional in nature and related to school business. If communicating via text is necessary for your job, such as a coach, please use district-authorized apps and methods for communicating with students. Educators must adhere to the acceptable use policies created by the district. The following rules have been created to address frequent problem areas. Do not access pornography or other inappropriate materials on district computers, whether you are on school property or elsewhere. If you accidentally click on an inappropriate site or image, quickly exit out of it and notify your supervisor that you have accidentally clicked on something that may be deemed as inappropriate. However, the ITS department, as well as the Employee Relations Department, realizes that sites can be reached accidentally, and it matters how long you were on the site and whether you were clicking around on the site. Next, do not sell or pawn district property. The district does an inventory and will discover that the items are missing. The information will be handed over to law enforcement. Do not allow students to use your credentials to sign into your computer and/or computers that they are not authorized to be on. They could potentially access inappropriate material using a teacher's credentials. They must use their login information only. Employees should not use their email for personal matters. District email is public record. All communication must be appropriate and professional. Employees should not participate in chain emails or other inappropriate exchanges. Keep account passwords confidential. Users are ultimately responsible for activity that occurs under their account and their assigned equipment. Please ensure that personal social media accounts are set to private. Do not friend or accept friend requests from students. If your social media posts possess profane, insensitive, or offensive language or images that the public can see, it may hurt your effectiveness as a school district employee. As an educator and employee of St. Lucie Public Schools, you need to make sure you are following the video procedural guide for the district. Please be aware that you cannot show movies or videos in your classroom unless they align to the curriculum and are approved by administration. Additionally, only G-rated movies, shows, and videos can be played in class unless you receive administration approval and parent permission forms are signed. Even if something is approved by administration, please view the content in its entirety prior to showing it in your classroom. With today's technology, videos, movies, and other content can easily be edited, and you need to make sure that what you are viewing is appropriate before showing it to students. Full-length movies cannot be shown in class unless it is for a school-approved activity and approved by school administration. Bullying rises to the level of unlawful harassment when one or more persons systematically or chronically inflicts physical hurt or psychological distress on one or more students or employees. It is defined as an unwanted or unrepeated written, verbal, or physical behavior, including any threatening, insulting, or dehumanizing gesture by an adult or student that is severe or pervasive enough to create an intimidating, hostile, or offensive educational environment, cause discomfort or humiliation, or unreasonably interfere with the individual's school performance or participation. This unlawful harassment may include, but not limited to, the following: teasing, threats, intimidation, stalking, cyberstalking, cyberbullying, physical violence, theft, sexual, religious, or racial harassment, public humiliation, or destruction of property. Harassment means any threatening, insulting, or dehumanizing gesture, use of data or computer software, or written, verbal, or physical conduct directed against a student or school employee that places a student or school employee in reasonable fear of harm to his or her person or damage to his or her property, has the effect of substantially interfering with a student's educational performance, opportunities, or benefits, or has the effect of substantially disrupting the orderly operation of a school. If a student reports information to you that makes you believe they have been bullied by another student, please report it to your supervisor. If you have been bullied or harassed by another employee, please also report that to your supervisor. If you feel your supervisor is bullying you or harassing you, you may contact me or the Human Resources Administrator, who will get the information to me. Bullying and harassment, as stated above, is not disagreeing or not getting along with an employee. It is repeated behavior over a period of time. If your supervisor is telling you to do something, and even if they are becoming firm with telling you to do something because you are refusing to do it, that is not considered bullying or harassment. Sexual harassment and other forms of illegal harassment towards a student, colleague, volunteer, or visitor are forbidden and will not be tolerated. Unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature, when submission to such conduct is made either implicitly or explicitly a term or condition of an individual's employment or status in a class, educational program, or activity. Submission or rejection of such conduct by an individual is used as a basis for employment or educational decisions affecting such individual, or such conduct has the purpose or effect of interfering with the individual's work or educational performance, of creating an intimidating, hostile, or offensive working and/or learning environment, or of interfering with one's ability to participate in or benefit from a class or an educational program or activity. Sexual harassment may involve the behavior of a person of any gender against a person of the same or other gender. The EEOC has stated harassment is illegal when it is so frequent or severe that it creates a hostile or offensive work environment, or when it results in an adverse employment decision, such as the victim being fired or demoted. Teasing, offhand remarks, and isolated incidents that are not very serious may not be prohibited by law, but may be a violation of the district's policies and procedures. Behaviors that interfere with work performance or create an intimidating, hostile, or offensive work environment are considered harassment. Do not harass students. Respect their differences. What you intend as humor may, in fact, be cultural bias or harassment. In regards to an employee on employee sexual harassment, it must be severe or repeated. However, feel free to notify your supervisor or district staff of something that makes you feel uncomfortable. If your supervisor or another employee is placing their hands on you when communicating with you, as in the picture above, it is in your best interest to tell them that it makes you feel uncomfortable. Unless in severe cases of sexual touching or harassing comments, an employee cannot be disciplined if they are engaging in minor offenses that make you feel uncomfortable when you have not told them that it makes you feel uncomfortable. If nothing else, please notify your supervisor and they can have a conversation with the employee. Regardless, ignorance is not an excuse for engaging in unprofessional behavior towards another employee. If you feel you are being harassed or sexually harassed, please notify your supervisor. If it is your supervisor that is harassing you, please notify their supervisor, myself, or an administrator in HR. Reporting misconduct is a requirement. Your responsibility as an employee is to report the information. This is not about snitches get stitches. It is understandable that some things may be hard to report because you work closely with a person who the allegations are against. However, your concern should always be for the student. By reporting the incident, you are not saying the person should be disciplined. It is not your duty to determine whether the person should be disciplined or whether reporting the incident will make your working relationship uncomfortable. If reporting an allegation is making your working relationships uncomfortable, please report that to your administrator. However, your primary concern is always for the students enrolled in the district. Reporting misconduct towards a student is a requirement. If a student reports something to you and you believe the information to be untrue, you must report it anyway. This protection is as much for the employee's sake as for the student. If a student is making false allegations, the district needs the record of the report that the allegation was investigated. In accordance with Florida statute, any person who knows or has reasonable cause to suspect that a child is abused, abandoned, or neglected by a parent, legal custodian, caregiver, or other person responsible for the child's welfare, or that a child is in need of supervision and care and has no parent, legal custodian, or responsible adult, relative immediately known and available to provide supervision and care, shall report such knowledge or suspicion to the Department of Children and Families. It is a third-degree felony if a person has knowledge of abuse and fails to report it. So, if a student reports to you that they have been injured, abandoned, or neglected as a result of the conduct of another employee, please make your supervisor aware and make sure DCF is contacted. Employees can report by calling or submitting the information on the DCF website. The abuse hotline is 1-800-96-ABUSE. School district employees are mandatory reporters and are required to report known or suspected abuse and neglect of a child to the Department of Children and Families. When you report, you will be asked to identify yourself, but the report will be kept confidential. When a child informs you that he or she is being harmed by an adult, or you notice signs of physical, mental, or sexual abuse or neglect, it is not your job to investigate the matter. You must take all allegations seriously, and the information must be reported to DCF. Your supervisor must also be made aware of the situation and can make the call for you, but you are the one who saw the incident and you were told the information. So please make sure your supervisor makes the call. Additionally, it is very important to know that child-on-child sexual contact must be reported to DCF. Employees have been arrested for having knowledge of child-on-child sexual contact and failing to report it to DCF. Leave of absences shall be used for the purpose set forth in the leave request. A staff member who uses leave for purposes other than that set forth in the leave request may be subject to discipline up to and including termination. A leave shall not be granted to any employee to accept other employment. Accepting employment while on leave of absence cancels the leave automatically. The person on leave will be notified that he or she must return to work with the school board immediately, resign, or be terminated. Except for cases of emergency, a request for leave should be filed at least 10 days before the date on which the proposed leave is to become effective. 3 working days of failure to report for duty or be on approved leave will be determined as abandonment of position, and the employee will be subject to termination. Every employee holds an important role in the education of our students. Leave is available to take sparingly and when needed. However, continued absenteeism of one employee can affect several aspects of a school or department. When a teacher has to cover another teacher's classroom, or an employee has to cover another employee's role within the district, it affects everyone. Please take this into consideration when taking a leave of absence. This was touched on previously in this presentation, but this is the most important thing that will keep you from receiving discipline when dealing with students. You must remain the adult in the situation. Most employees that receive discipline receive it because of an interaction with a student, and it is because they do not remain the adult. Students will have bad days and will push your buttons. You must remain professional and not let them get under your skin. If a student pushes you, that does not give you the right to push back. Call for assistance. However, this does not mean that you cannot defend yourself or others. Some situations are tougher than others. If you remain professional and do what you know is best, you will have a successful career for St. Lucie Public Schools. Thank you for listening to this presentation on ethics in education.